Good evening, my professors, my teachers, my mentors, my seniors at the bar and at the bench, and various people who have influenced and shaped my life 22 years ago. As I posted on my Facebook wall today, that I mark 22 years of being called to the bar. In other words, 22 years of becoming a lawyer. As I indicated, I am a son of the cocoa farmers, and I don't take what God has done with me for granted. And I also deem it a sacred duty that I owe obligation to society to do whatever I can to continue to impact society positively. Therefore, I have chosen to do a short public lecture to mark my 22nd year at the bar. As I have indicated, I was called to the bar alongside my classmates on 3rd October 2003. So I propose to speak briefly on a topic looking back at Ghanaian law 22 years ago, a reflection on the emergence of healthcare or medical law as a field of law and practice in Ghana. I have chosen this topic for two reasons. One, the fact that it is an area which was relatively unknown as far as our jurisdiction is concerned, or relatively undeveloped. And along the line, I developed interest when I decided to further my academic legal studies at the terminal degree level, that is my PhD. I decided to venture into a relatively new area from the point of view of my own experience in learning law and practicing law in Ghana. And that explains why I have chosen to speak to the topic, looking back at Ghanaian law 22 years ago, a reflection on the emergence of healthcare medical law as a field of law and practice. Well, 22 years ago, when I was called to the Ghanaian bar, the phrase medical law, or more precisely, healthcare law, scarcely registered as a discrete field or as a stand-alone field of law in our courts, as it were, as well as in our classrooms or our law offices. Indeed, if you look at the syllabus or the curriculum of our law faculties, the law school, there was nothing like a course on healthcare law or medical law. And certainly, the way lawyers and judges are shaped, we are shaped largely by the legal education which we received and our own subsequent experiences, which we build along our career path or trajectory. Now, matters arising from clinical encounters tended to be folded into negligence, general negligence, criminal law, administrative law, as it were. Now, today, while the field, what we call medical law or healthcare law, is not yet fully matured in Ghana, it is unmistakably emerging, and I will always vote for that. And its emergence is driven by patient rights consciousness, regulatory reform, digital health, and steady trickle of case law as far as medical malpractice and medical negligence litigation is concerned. So in this anniversary lecture, my 22 years as a lawyer, I briefly recall where we stood 2 decades ago and explain what marks healthcare law out as a distinct legal field. In other words, when can we say that healthcare law has emerged as a field of law, so to speak? And then I will also sketch how English and Welsh experience catalyzed this field of law and try and draw practical lessons for Ghana's next decade. And of course, as I indicated, I'll use this opportunity to also draw on aspect of my doctoral research, which interrogated this very question. So where we stood around 2003, of course, the very year that myself and my good classmates, including David Asiedu, Nicholas Fredu Akwatin, William Kisi Ajabin, Professor Richard Opon, Gordon Jokoto, Ingrid Hackman, as she was then called, Gloria Boafuata, Justice Dr. Duse Poku, Justice Franklin Adanu, and Alex OWUSU, just to mention few of my classmates. Now, at the start of my practice, that when I was called to the bar 2003, Ghana's medical legal landscape was dominated by a handful, you could barely count, the negligence case law or decisions, and by professional self-regulation to an extent, not very effective. So litigation volumes were low, and the jurisprudence did not yet cohere around recognizable core principles such as patient autonomy or the right to information. We did not have significant, didn't have litigation around that at all. And in fact, the Ghana Health Service Patient Charter was then being rolled out and public awareness was uneven. The Ghana Health Service had started what they call the Patient Charter, the early 2000s, and it was being rolled out, and then it will take a while before it will become popular. And later on in 2012, when we have a public health pass, we find a way to give a legislative footing to it. So that was the picture. So the last decade, that is from the last 10 years, we can say, or little just above that, has witnessed significant legislative consolidation touching the health sector. So we have the Public Health Act of 2012, Act 851, the Mental Health Act of 2012, Act 846, Data Protection Act 2012, Act 843, Health Institutions and Facilities Act 2011, Act 829, Health Professions Regulatory Bodies Act 2013, Act 857, the National Health Insurance Act 2012, Act 852. So these enactment do not by themselves necessarily create a discipline or a field of law, but together they greatly expand the normative and institutional frame within which healthcare is delivered and supervised. So, here's a question. What makes healthcare law or medical law a distinct field? What makes it a discrete body of law? Well, in my thesis, which anybody at all can just access it from the thesis database, an aspect of it has also been published in developing healthcare law in Ghana. In my thesis, I proposed 4 indicators drawn from comparative legal scholarship that help us to decide when a body of law has crystallized into a field. So, in short, I noted that a sufficient volume of case law with factual peculiarities that demand specialized analysis. So, where you have significant volume or sufficient volume of case law, uh, emerging or crystallizing, and this body of case law has got factual or unique, peculiarities, and for that matter, they call for specialized analysis. 2, there should be a discernible body of dedicated or interventionist legislation. So just like the ones that I have just mentioned not long ago. 3, core principles or values that give the field both commonality and distinctiveness. And 4, academic sustainability. That is that which we are going to call a distinct field of law having emerged must be taught. So there should be teaching of it, there should be scholarship built around it, meaning that people should conduct research and publish, and there should be academic commentary in that particular area. Then there should be professional practice that reproduce the field over time. So we should have lawyers actively taking up cases and applying themselves rigorously to the unique elements of that particular area and pursuing these matters in court, and then the judges also applying themselves with and churning out the decision, which over time brings up a new norms and concept and consolidate the existing norms and continue to add to what makes that particular field special with the way that it is. So all these markers are important before we can say that a field has crystallized as a distinct body of law. So applying these indicators to Ghana in 2016, my study found an embryonic but incomplete field of healthcare or medical law, so to speak, in the sense that I noticed limited litigation beyond negligence. That yes, we had some litigation, but the litigation that one noticed are essentially around medical negligence, and beyond medical or clinical negligence, you don't see any other cases which seeks to engage or implicate other doctrines, important doctrines, mobilizing doctrines of healthcare law, medical law. Yeah, so then I also notice developing but often institution facing statutes. Yes, some legislation, as I indicated, have emerged, especially the 2011-2012 coming. But if you look at those legislation, you will notice that they may at best be called institution facing in the sense that they are crafted to either set up certain bodies or certain institutions, their institutional structures, and so on. And they don't do much in terms of normative standards. I also noticed early curricular presence that if you look at some of the approved curriculum by National Accreditation Board, now called GTEC at the time, for some universities, particularly Kwame Nkrumah University of Science and Technology Faculty of Law, and then University of Ghana School of Law to an extent, you could see that there had been an approval for medical law, but it had never been mounted as a course. It had never been taught as such. But thankfully, that has improved significantly. And Kenya University, for example, I was the first to mount the model medical law at undergraduate and also healthcare law and ethics at the master's level. And since 2015 coming, they've taught that course significantly. And then as we noticed, University of Ghana has also rolled out even a full-fledged program of Master of Arts and Master of Laws in medical law or healthcare law, as it were. So all these are later developments. And again, I also noted some growing scholarly interests, some scholars beginning to research and do some publication. So the conclusion then, that is at the time when I did the thesis work, and I will say now, is that the field, that is medical or healthcare law, exists in formation with scope for deliberate acceleration. So there's no doubt it is developing, but then there's still significant room for deliberate acceleration. Well, why does English and Welsh healthcare law matter in terms of it being a catalyst for stimulating the development of our own field of medical law, healthcare law in Ghana? Why does it matter? Well, England and Wales provide a useful comparator for Ghana for obvious reason, given our shared legal tradition, the colonial nexus, the common law tradition. Not to transplant rules wholesale, but to understand the drivers of disciplinary formation. So from the early 1980s, several currents converge, including the revival of liberal rights-inflected reasoning around patient autonomy, a flourishing bioethics discourse, rapid medical advances, including transplantation, assisted reproduction, life support technologies, and crucially, academic scholarship and entrepreneurship, as it were, as significant textbooks, courses, journals, conferences, scaffolded a new field. So jurisprudentially, the law moved from Bolam's professional-centered difference to a patient-centered standard in the case of Montgomery against Lancashire Health Board. which, as it were, underscored or institutionalized informed consent around what a reasonable patient will regard as material. And the UK Supreme Court in 2015 actually took the law a very step further than it was. Now, in the UK again, legislation systematized practice. So the Mental Health Act of 1983, of course, which has been subsequently amended, the Human Tissue Act of 2004, which has also been amended, and then the Mental Capacity Act of 2005, among others, together provided coherent, justifiable frameworks for capacity, consent, detention, tissue issue, and best interest decision making. I mean, quite apart from these legislative interventions and also scholarship, another important phenomenon which accelerated the development of this area of the law in England and Wales is what we call the public inquiries. Public inquiries into alleged significant scandals in medical practice. For example, the British Royal Infirmary, Dr. Harold Shipman's inquiry, so many of them. And these inquiries expose suppressed mistakes or errors, avoidable accidents in medical practice. And they were given significant publicity for two audiences: victims and patients generally on one hand, and healthcare professionals, and especially healthcare professionals who might have been involved in these scandals. Now, as these were actually given publicity, they shock the conscience of the actors. And it is expected that beyond regulatory and other interventions, it in itself going to serve as a check on healthcare professionals for their future or subsequent conduct so as to minimize such mistakes or even avoid it completely. Then, regulatory duty of candor, which were emphasized by these inquiries or reinforced a culture of accountability and transparency, which shaped both clinical governance and patients' procedural rights and entitlements. So the broader point with respect to how this area of the law developed very fast in England and Wales, and for that matter, provides inspiration for our jurisdiction is institutional. So disciplines consolidate when law's doctrinal moves, that is case law or decisional law, the law's techniques, that is the various legislation, and then the law's communities, that is the teaching and practice of the law, reinforce each other around shared values. And what are the shared values? Patient empowerment, dignity, safety, and transparency. So if all the various components, the various elements which constitute the architecture, or what they call healthcare law, are working, they will mutually reinforce each other. So, lawmakers through various legislation make laws which seeks to, for example, enhance patient empowerment, dignity, safety, and transparency. Now, you get practitioners taking up cases to try and vindicate or to try and have these principles upheld by the law courts. And then the law courts who embracing the challenge to look into these matters. Now, that way, we will be getting these shared values deepened, and that provides the basis for consolidation of healthcare law or medical law, as it were. Now, Ghana, since 2003, are there any gains to be consolidated? No doubt, Ghana has made critical strides. Our patient charter states the rights and responsibilities of service users and providers. It provides an ethical legal vocabulary that can be mobilized in litigation, policy, articulation, and hospital practice. And in fact, as I indicated, this has now been made part of the legislation. So if you look at the Public Health Act, in terms of Section 167, it makes reference to that in the CIS schedule, in which the patient charter has actually been included in our law. Again, during the same period, we remember the Elizabeth VAR against Lisa Hospital and Fertility Center litigation, which was decided. It didn't go on appeal, just at the High Court, but it's still significant and is emblematic of what we are talking about in terms of development of this area. So the High Court in the Elizabeth VAR case, as you remember, ordered disclosure of medical records. And this is very significant because it advances patients' right of access to information regarding their health, as it were. And not until that case, we had not had any decisional law regarding whether a patient could, for example, compel a facility to make available his or her medical records. And mind you, this case predated the Data Protection Act as well. Now, no doubt, regulatory architecture has taken, if you are to look at the whole picture since, 2003, the Public Health Act 2012 codifies wide-ranging powers on communicable disease control and safety. The Mental Health Act 2012 establishes rights, safeguards, and mental health authority. The Data Protection Act 2012 secures a modern data rights regime directly relevant to confidentiality, secondary use, and access to records. We also have the HEFRA under the Health Facilities Act, which licenses facilities as it were. Then we also have the Health Professions Regulatory Bodies Act, which rationalizes professional regulation. And of course, we also have the National Health Insurance Act, which provide structured financing, and then who are supposed to benefit from the public funded healthcare system. Again, looking back, digital health has also introduced new vectors of duty and risk. So we have telemedicine, electronic health records, and health analytics. And I must say that a few years ago, I had the privilege of being invited by the Ghana College of Surgeons and Physicians to present a paper during their annual scientific conference on legal and ethical dimensions of telemedicine. So all these are indications of how this particular aspect is also developing. So they all press the case for coherent governance of clinical safety, cyber security, cross-border data flows, and algorithmic decision support, especially in this age of artificial intelligence. So our national e-health strategy, as it were, rightly anticipated this trend, and there has been some pilots projects of telemedicine in some parts of the country, including the Ashanti. Now, what still lacks behind is volume and range of adjudication. If you still look at this area of the law, apart from medical negligence, we don't have any significant litigation. But medical law and healthcare law is not just equal to medical negligence. Medical negligence is just a subset, it's just an aspect of healthcare or medical law. And there are so many other aspects which are important. And in fact, a lot of things are going on in our hospitals and health facilities, which in other countries like England and Wales, for example, and other jurisdictions, the health facilities will have had to go to court to seek opinion of the court as to whether certain choices could be made regarding treatment options and certain procedures. But here in Ghana, things are just swept under the carpet and anything goes, as it were. And the only time you see people taking up a matter is when something has really gone wrong and then the patient is complaining. Then we have this medical negligence. But as I indicated, it's not only about medical negligence which should be taken up. There are so many other things. Refusal of treatment and so on. Discontinuation of treatment or carrying out even separation of, let's say, conjoined twins, just like the rare conjoined twins case that we've had in other jurisdictions, particularly so where the prognosis is said that when the procedure is done, there's going to be death of one of them, or you may even lose both. And having, having knowledge of the criminal offense of murder and manslaughter, you may want to be careful as to whether you like to do such a procedure or you like to go to court for the court to give a certain declaration as to whether certain things can be done or not. So all these things are not done. So in terms of volume and range of adjudication, we're still lagging behind. And as I've indicated, beyond negligence, we don't have any cases which are actually pursued. Again, we also lag behind as far as sharper articulation of core principles are concerned, like autonomy, dignity, proportionality in public health. Of course, during the COVID-19, some interests, of course, were forced, just by circumstances to take public health issues serious, and that provided an avenue for a whole discussions to be done in matters impinging on public health. And again, there's also the need for systematic curricular embedding across law, medical, and nursing schools. So that is very important. And medical law, for example, should be made a core subject, or the list that can be done is that it should be made as an elective, and it should be mounted in the law schools, the medical schools, and then the nursing schools. Now, as I bring my short public lecture to a close, what lessons can be drawn for Ghana's next decade? And I would like to reiterate recommendations that I made in my doctoral thesis. So one, keep patient empowerment as the field's organizing value. So let us have understanding or consensus that medical law is seeking to empower patients, not in a confrontational sense, okay? So, of course, people get it wrong when you say that patients should be empowered. It doesn't mean that uh, just empower the patient to go and just sue the hospitals or the doctors. That is not the point at all. Now, the English and Welsh experience shows that when autonomy and rights acquire doctrinal teeth through litigation, like cases, and also dedicated legislation and guidance, clinical practice shifts. So there's a positive impact on quality in clinical practice, because patients are empowered to, for example, ask questions about their diagnosis, treatment options, and so on, procedures which are being done. And once a patient, for example, know that they can make such inquiries, certainly it's going to serve as a check on the healthcare professionals to sit up or up their game. And at the end of the day, their skills will be deployed at the highest level, quality will improve, and patient safety definitely will be the outcome, and everybody will benefit. So, in Ghana, our statutory and constitutional materials, of course, can easily allow a Ghanaian model of healthcare law that is right sensitive yet context appropriate. And this is very important because we often think that because of our resources constrained environment, we should not talk about principles or the doctrines which constitute the healthcare or medical law at all, because we'll be told that, well, we don't have enough healthcare professionals, we don't have enough health facilities, and so on. No, and that is why the law courts, our judges, and the academics, of course, will have to embrace the challenge, not just to borrow principles which have been developed in other jurisdictions and seek to apply them here, hook, line, and sinker. No, we must tweak, we must modify, adapt these principles in a way which will suit our context. So, yes, we can model our healthcare law around right sensitive culture. At the same time, it will be appropriate to our context based upon our peculiar circumstances. Another uh, point which I proposed and which I'm proposing as I mark the 22nd anniversary is that there should be, I call upon the government, particularly the Minister of Health and then the government, to set up a targeted public inquiry into patient safety and hospital organization. You have so many commissions of inquiries, but as far as my research indicates, there has not been any focused public inquiry into patient safety and also hospital organization. And yes, if you look at our constitution, it provides for commission of inquiry into matters of public interest. So if you are talking about matters of public interest, certainly when it comes to health, when it comes to patient safety, these are matters of public interest. You and I can all be affected. You and I can all be affected. And in fact, my interest in this particular area of the law developed when my father died in 2005. And after organizing a funeral inexperience, I became so sick. And as I was seeking medical treatment, my own experiences and observation were very much stuck in my memory. So that when I decided to go and do terminal degree, and I was looking for an area to look into, the experience that I had actually influenced me to uh, explore how this particular area of the law could be developed in our jurisdiction. So I think that if you get a health-focused inquiry, I mean, similar to the ones which have happened in some other jurisdiction, it will help build an evidence base for statutory and regulatory reform and provide a catalyst for a culture of candor, which would actually also respect patient voices. So let's look at this scenario. Supposing that we have a commission of inquiry into patient safety, we can start from the public, public sector or public hospitals, the public hospitals, and we say that we define a period, the last 5 years or the last 10 years. We can define the period. Anybody who has had any experience that he or she is not happy about regarding his clinical experience in any of the stated facilities should come out and then testify before the commission so that we document the experiences similar to what we witnessed in this country. I think during President Kufuor's time when we had the National Reconciliation Commission. And as we give the platform to victims and patients to come and tell their stories, and they are carried in the media, they become a subject matter of continuous national discussion and debate. The bad things which are going on in our hospitals or in our clinics will certainly go down because healthcare professionals, their own conscience will be shocked when stories are being told by patients, when other healthcare professionals are also testifying about what they've observed their peers do, which in their professional judgment they think ought not to be done. Now, when all these things are being told and they are properly documented and they are giving the requisite publicity, it will certainly uh, you know, weigh on the mind of all healthcare professionals and it will check how they do their work. And all of us will be better off and all of us will be the winners. So uh, I made that call in my thesis. I am still reiterating that call to be made. I mean, I'm reiterating that call that the commissioner of inquiry or the public inquiry should be held. It's very important. And that should also provide a bit, a sort of like a watershed, if you like, a moment in trying to open a new chapter of enhanced patient safety and reducing medical malpractice litigation. So, therefore, when people are encouraged to come and tell their stories, not so much of they going to litigate, but we getting the evidence and trying to see what can be learned from it in terms of recommendation for policy adjustment and so on. It will certainly let the incidence of medical malpractice go down. Well, another point which I also recommend moving forward is establishment of a patient rights ombudsman, PRO, establishment of a patient rights ombudsman. Well, in my thesis, uh, I recommended either a dedicated standalone patient rights ombudsman or a well-resourced unit within Commission on Human Rights and Administrative Justice with powers to inspect, audit, and resolve complaints systematically. Now, this, in my view, will complement professional regulation. For example, what the healthcare professional regulation bodies do, like Medical and Dental Council, Nurses and Midwives Council, Pharmacy Council, and so on. As this particular body, be it the Patient Rights Ombudsman or the well-resourced unit within the SRAG, will be focused squarely on patient rights and institutional culture. So here we are foreseeing a situation where the patient rights ombudsman will be receiving complaints and grievances into patients adverse complaint as far as their clinical experiences are concerned and so on. Or uh, there can be unannounced visits and audits by the patient rights ombudsman to find out what is going on in certain facilities with respect to patients, as it were. I also uh, recommended that healthcare law or medical law and ethics should be embedded across curriculum. And I'm happy to observe that uh, the past 8 years, the past 8 years to 9 years, even 10 years, we may say even 10 years, because they started teaching this particular area in 2015. There has been a significant uh, improvement in that regard. So law schools should offer core and advanced modules. And of course, University of Ghana should also be applauded. Under the auspices of Professor Tukuba, the University of Ghana University of Ghana School of Law has actually rolled out the master's degree, MA and LLM in healthcare law and ethics, and that is very commendable. And again, the medical schools, the nursing schools should also teach some of these these modules. And of course, this is how the field of law sustains itself through teaching, research, and practice specialization. Again, with respect to access to medical records and duty of candor, the case of Elizabeth Var, as we noted, actually points the way. And of course, at 843, has also provided data subjects rights. So, but there's still the need for a clearer statutory rights of access to health records with narrow and proportionate exemptions plus a codified duty of candor for adverse events to actually be adopted. So we should get either a legislation or some form of a delegated legislation, because if you look at some of the, for example, the Data Protection Act and so on, it can provide the basis for an LI being made. And we can have an LI which provide the parameters regarding how medical records, for example, should be stored, how they can be assessed by the data subjects or like the patient, as the case may be. All the necessary guidelines are provided in such an LI, as the case may be. And finally, we should also update digital health governance. It is important to build on the 2010 e-health strategy by adopting interoperable standards, robust security baselines, fair data principles, and patient consent models, so that the innovation does not ignore or undermine patients' rights, as it were. So therefore, when I look back to my call as a lawyer 22 years ago, I see how far Ghana has traveled and how much we can yet do. Healthcare law will not coalesce by accident. It will not happen by accident. It requires a conscious knitting together of case law, legislation, institutional design, and pedagogy around the patient. So if we put patient empowerment at the center, we commission the right public inquiries, create complaint-solving institutions like the Patient Rights Ombudsman or a dedicated unit within the SRAJ. We clarify access to records, and we teach the subject well. The next decade can deliver a Ghanaian law of healthcare that is principled, practical, and proudly our own. That, to my mind, will be a fitting anniversary gift to the bar and to the public whom we serve. I thank you very much for celebrating our bar anniversary with us. Those who are interested in the matters that I have discussed, you can actually go to University of Ghana bookshop. That is a Kingdom bookshop. And I have a book called Developing Healthcare Law in Ghana, towards patient empowerment. You can grab a copy and then you read and get more about this. Of course, I also have so many other books, including the Medical Law in Ghana Primer, and then Essentials of Lawyering in Africa, and then the Ghana Legal System and Legal Method, among others. So thank you very much, and God bless us all so that we're able to celebrate more anniversary of our call and reflect on development of Ghanaian law. Thank you. And to my classmates, happy anniversary to all of us. And may the souls of our classmates that we have lost rest in peace, including the most recent loss, Mr. Hammond, common law. Thank you very much. God bless you all.